Good day, everyone. Our topic for today is the law on indeterminate sentence. So under Act number 4103, how is the law applied? So under Section 1, it is actually classified its application into whether or not it is penalized under the SPL or the Special Penal Laws or with the Revised Penal Code. In Section 1, it provides that if the prison sentence of an offense is punished by a special penal law, ISL shall be applied as follows. The court shall impose the accused an imprisonment which shall not be less than the minimum term of imprisonment provided for that particular law for the offense to which he is charged, and the maximum term of which shall not exceed the maximum fixed by the law. Now, if the same is imposed by the Revised Penal Code, the maximum term of the penalty to be imposed upon the convict is that which could be properly imposed under the Revised Penal Code, considering the aggravating and mitigating circumstances, while the minimum term is within the range of the penalty 1 degree lower than that prescribed by the RPC without considering the attending circumstances. But when there is a privilege mitigating circumstance, take note that in arriving at the indeterminate penalty of the accused, we do not consider first the aggravating or mitigating. So the mitigating referred to in the law is referring to the ordinary mitigating. But when there is a privilege mitigating circumstance, so that the penalty has to be lowered by 1 degree, the starting point for determining the minimum term of the indeterminate penalty is the penalty next lower than that prescribed by the code for the offense. In other words, you have to consider it, apply it right then and there to come up with the penalty to be imposed upon the accused. The purpose of which is that any person who shall have been so convicted and sentenced and shall have served the minimum sentence imposed hereunder, he may be released on parole in accordance with the provisions of this act. Now, take note that while the imposition of an indeterminate sentence is mandatory, the provisions herein shall not be applied if the accused is disqualified or he falls to any of the disqualification provided under Section 2. And what are they? ISL. The provisions of the ISL shall not be applicable if the penalty imposed upon the accused is death penalty or life imprisonment. And for purposes of the application of the law, it shall also include reclusion perpetua. It shall likewise not apply if the accused is convicted of treason, conspiracy or proposal to commit treason, or those convicted of misprision of treason, sedition, espionage, or those convicted with piracy. Further, it shall likewise not apply to habitual delinquents. So I think you still remember who a habitual delinquent is. So if the accused is only a recidivist, then ISL has to be applied to him. Those who have escaped from confinement or evaded sentence, those who have been granted conditional pardon by the chief executive and violated the terms thereof, those whose term of imprisonment does not exceed 1 year, or those whose sentence by final judgment at the time of the approval of this act, except as provided in Section 5 thereof, those who were sentenced to destierro or suspension, ISL does not apply. And if the penalty, or in other words, if the penalty does not exceed 1 year, so here, to those whose maximum term of imprisonment does not exceed 1 year, imposition of the ISL shall not apply as provided under Section 2. In other words, it shall be mandatory for as long as you are not included in the enumeration in Section 2. Okay, so imposition, mandatory. The court must, instead of a single fixed penalty, determine 2 penalties referred to in the Indeterminate Sentence Law, and we are referring to the maximum of the indeterminate penalty, which is the prescribed penalty of the offense to which the accused is found liable for, and the minimum, which is the next degree lower of the prescribed penalty. So let's apply the law. So first, if the accused is punished by a special law, A is convicted of illegal possession of small arms, punishable by prisión mayor in its medium period. So the prisión mayor medium is the prescribed penalty. The court can impose upon him an indeterminate sentence from 8 years and 1 day as minimum to 10 years as maximum. Remember that is the entire duration of prisión mayor medium. So for as long as what the law says, for as long as the minimum is not less than the minimum and the maximum is not more than the maximum provided for by law. Same as saying that you can actually also impose upon him exactly the same penalty as provided for under the law. Now, how about if the convict is punished under the revised penal code? Helpful in applying ISL is the graduated scale, the table of penalties, the duration of each of the penalty, and the ordinary mitigating circumstances. Because in ordinary mitigating circumstances, you can offset it with generic aggravating. So to recall your memory, to recall your knowledge on the offsetting, so if you have there 1 mitigating and 0 aggravating, the penalty to be imposed upon the accused would be in the minimum period. And if there is no mitigating and there is 1 aggravating, the penalty to be imposed upon the accused is the maximum period. If there is 1 mitigating and 1 aggravating, offset it. It is as if there is no aggravating or no mitigating attending the commission of the crime, hence the medium period shall be imposed. 0 mitigating, 0 aggravating, medium period. So we are actually talking about the divisible penalties. Now, what about if there is a privilege mitigating? And what are the privilege mitigating? You have there minority, as well as Article 64, which provides that if there are 2 or more mitigating and no aggravating attending the commission of the crime, that is considered to be privilege mitigating. And then you have there Article 63, if not wholly excusable, not wholly justified, not wholly exempting, that is privilege for as long as majority of the elements are present. So these are helpful in applying ISL if punished under the revised penal code. So let's have some illustration. A was prosecuted for and was found guilty after a regular trial of homicide under Article 249, which prescribes the penalty of reclusion temporal. So the prescribed penalty here is reclusion temporal. So if you were the judge, what indeterminate penalty shall you impose upon the accused if, sorry, when neither mitigating nor aggravating attended the commission of the crime? So since no mitigating, no aggravating, as a rule, the prescribed penalty shall be imposed in the medium period. And the minimum term shall be in anywhere within the range of prisión mayor, which is the penalty next lower from reclusión temporal. So how shall the judge impose it in his judgment? So let's go to the dispositive portion right away. So finding the accused guilty beyond reasonable doubt, he is hereby sentenced to an indeterminate penalty of 6 years and 1 day of prisión mayor as minimum, to 17 years and 4 months of reclusion temporal medium as maximum of the indeterminate penalty. What would be the penalty if there is one ordinary mitigating? Example, the accused pleaded guilty before the presentation of evidence by the prosecution. So what would be the prescribed penalty? The maximum of the indeterminate penalty shall be reclusion temporal minimum period. How about the minimum of the indeterminate penalty? Within any range of prisión mayor, which is the penalty next lower from reclusion temporal. Now, how about, or what would be the penalty to be imposed upon the accused when there is one aggravating, such as disregard the respect due the offended party? So what would happen now? Now, we are actually talking of the same facts. Accused was charged and convicted for homicide. So you have there one aggravating. The prescribed penalty shall be as follows. The maximum of the indeterminate penalty shall be reclusion temporal maximum because of the presence of one aggravating. How about the minimum of the indeterminate penalty? Within any range of prisión mayor, which is the penalty next lower from reclusion temporal. How about if there are mitigating and aggravating circumstances? So when A committed a crime at nighttime and he voluntarily surrendered and pleaded guilty, so we apply offsetting. So after applying offsetting, there is one more mitigating left. So what would be the indeterminate penalty to be imposed upon the accused? Reclusion temporal minimum as the maximum of the indeterminate penalty, and the minimum shall be within any range of prisión mayor, which is the penalty next lower from reclusion temporal. Now, how about if it is it's a complex crime under Article 48? Now, remember, if the accused is charged with a complex crime, the penalty to be imposed is the penalty of the most serious crime. So in direct assault with frustrated homicide, for example, so frustrated homicide is more serious than direct assault. So the prescribed penalty for frustrated homicide would be our consideration. Now, since it is frustrated, so from the prescribed penalty of homicide of reclusion temporal, then the prescribed penalty of frustrated homicide shall be prisión mayor. 1 degree lower from reclusion temporal, the prescribed penalty for consummated homicide. So what would be the effect now? What would be the indeterminate penalty to be imposed upon the accused? The maximum of the indeterminate penalty shall be prisión mayor to be imposed in the maximum period being a complex crime, because the law says penalty of the most serious in the maximum period. Hence, the maximum of the indeterminate penalty shall be prison mayor maximum, and the minimum shall be within any range of prison correctional, which is the penalty next lower in degree of the prescribed penalty. Now, how about when the penalty lower by 2 degrees than that prescribed by law for the crime treated and there is one aggravating? Example, A threatened B to kill B if the latter would not give him a certain sum of money. A failed to attain his purpose because he was arrested by the police officers. So in grave threats under Article 282, it provides that the penalty shall be 2 degrees lower than that of the crime threatened of. So if he threatened to kill, so it could be homicide. Prescribed penalty is reclusion temporal. So for grave threat, the penalty, the prescribed penalty shall be 2 degrees lower. So that would mean prison correctional. So what would be the indeterminate penalty now of the accused? So the maximum of the indeterminate penalty shall be prison correctional maximum because of the presence of one aggravating, which is relationship. What would be the minimum within any range of aristo mayor as the minimum of the indeterminate penalty being the penalty next lower in degree of the prescribed penalty. On another illustration, when the accused is convicted of a complex crime and there are 2 mitigating circumstances without aggravating. So when we say 2 mitigating circumstances, 0 aggravating, that is privilege mitigating. So how do we apply it now? So to illustrate, A committed staffa through falsification of public document. So being a complex crime, so the penalty of the more serious, which is falsification, applied in the maximum period pursuant to Article 48, will be imposed. So the penalty of falsification is prison mayor to its full extent and fine. And there being 2 mitigating, voluntary surrender and plea of guilty without any aggravating, so the penalty next lower shall be imposed. So our prescribed penalty now shall be prison correctional in the maximum period as the maximum of the indeterminate penalty. Why maximum period? Because of the provision of Article 48. That the penalty of the most serious imposed in the maximum period shall be imposed. And what would be the minimum? So the minimum here would be within any range of aristo mayor, which is the penalty next lower in degree than the prescribed penalty. How do we apply indeterminate sentence when there are privilege mitigating and ordinary mitigating circumstances? So, when there is a privilege mitigating circumstance such as minority or incomplete defense, an ordinary mitigating circumstance such as plea of guilty or voluntary surrender, the rule is lower first the penalty prescribed by the code for the offense by 1 degree. Reason? Because of the presence of the privilege mitigating. So after lowering, that would be our prescribed penalty. That would be the maximum of the indeterminate penalty. And from then on, you look for the penalty next lower because that would be the minimum of the indeterminate penalty. Example, A CICL was found guilty of murder upon a plea of guilty. So you have their minority, privilege mitigating, plea of guilty ordinary. The court suspend the sentence and order the commitment of the CICL to the training school for boys in accordance with Article 80. Because he is incorrigible in the training school, A was returned to the court for the imposition of the proper penalty. The court imposed an indeterminate penalty of 6 years and 1 day of prison mayor as minimum to 12 years and 1 day of reclusion temporal as maximum. Is the penalty correctly imposed? Take note that he was charged for murder. Prescribed penalty for murder is reclusion perpetua. But since there is the presence of privilege mitigating circumstance of minority, then the maximum of the prescribed penalty is reclusion temporal. Reclusion temporal, and the minimum shall be within any range of prison mayor. And since there is one more ordinary mitigating, so your reclusion temporal shall be imposed in the minimum period as maximum of your indeterminate penalty. Hence, the penalty imposed by the court is proper. How do we apply indeterminate penalty when there are two privilege mitigating and ordinary mitigating circumstance? So to further illustrate, let us say that there are two privilege mitigating. Minority, voluntary surrender and pleaded guilty, 0 aggravating. After the suspension of sentence, because he was incorrigible, so the sentence was promulgated. So what would be now the penalty to be imposed upon the CICL plus the presence of the two ordinary mitigating, 0 aggravating, meaning to say there are two privilege mitigating. So from the penalty of murder, you go, you lower down 2 degrees down the scale, which would be prison mayor. Prison mayor to be imposed in the minimum period because of the presence of the other ordinary mitigating circumstance. And your minimum of the indeterminate penalty shall be within any range of prison correctional as minimum of your indeterminate penalty. How do you apply indeterminate penalty when there is incomplete defense with two ordinary mitigating circumstances and without any aggravating? A killed B in incomplete self-defense, who also acted with obfuscation and voluntary surrender to the authorities after killing. So there are two. So penalty of homicide is reclusion temporal, lowered by how many? 3 degrees in all. Why? Minority, that is privilege, 1 degree lower. And in Article 64, paragraph B, if majority of the elements to make the defense to justify the act, the penalty to be imposed upon him is 2 degrees lower. That's why it is 3 in all. So from reclusion temporal, you go down the graduated scale 3 down. So reclusion temporal, prison mayor, prison correctional, arresto mayor. Your prescribed penalty now is arresto mayor. No more minimum. Why? Because arresto mayor is already below 1 year. Take note that one of the disqualification for the application of the ISL if the penalty imposed is less than 1 year. Hence, the penalty imposed the penalty to be imposed upon the accused is arresto mayor. As simple as that. How about probation law? So the salient features of this particular amendment, RA 10707, are just few. But it doesn't mean that PD 968 has been repealed completely. The amendment is on specific portions only. Hence, you have to read both laws. So, grant of probation, Section 4, which is under the new law, the amendment. The same thing, if the accused have been convicted and sentenced to a provisional penalty, he may apply within the period of perfecting an appeal. So if he had applied for probation, then the the execution of the sentence shall be suspended and place the defendant on probation for such period and upon such terms and conditions as it may deem best. Further, under Section 4 still, no application for probation shall be entertained or granted if the defendant has perfected an appeal. This is the general rule. And here comes the qualification under the amendment. Provided that when a judgment of conviction is non-probationable, meaning to say the trial court imposes upon him a non-probational, meaning to say more than 6 years, is appealed or reviewed, and such judgment is modified through the imposition of a probationable penalty, the defendant shall be allowed to apply for probation based on the modified decision before such decision becomes final. In other words, probation shall only be applicable if the reason of the accused in filing the appeal is purposely to question the non-probationable penalty imposed by the trial court to the accused. Because basically, the accused was not given a chance to avail of the same the soonest time possible because of the error that was not attributable to him. So, on appeal, if his appeal was granted and the decision was modified, and now he is now being imposed a probationable penalty, under that circumstance, he is allowed to apply for probation based on the modified decision before it becomes final. When shall it becomes final? Remember, orders or judgments will become final after 15 days. So you have to do it before it becomes final. Where will you file it? Either in the trial court, who imposes the accused a non-probationable penalty, or in the trial court to which the case has been re-raffled. Let's continue with Section 4 still. Now, in a case involving several defendants, where some have taken further appeal and the other defendants may apply for probation by submitting a written application and attaching thereto a certified true copy of the judgment of conviction. Now, this is especially true if there are more than one accused in a particular case. The trial court already imposes upon him a probationable penalty, but one of the accused filed an appeal. Would that be a ground for disqualification? No, because these remedies are personal upon the accused. So those accused who does not want to appeal may apply for probation if the penalty imposed by the trial court is probationable. He will not be barred or prevented from applying probation because one of the accused filed an appeal. Okay? It is personal. Now, what if it is non-probationable and one of the accused filed the appeal purposely to question the imposition of the non-probationable penalty by the trial court, while the rest prefer to serve the sentence imposed by the trial court? Now, let us say that on appeal, the judgment was modified and imposing the penalty, a probationable penalty. What would happen now? Now, the appellant who had that who obtained that probationable penalty on appeal may apply for probation before that modified decision becomes final. Now, how about those accused who did not file an appeal? Can they also apply for probation? The answer would be no. Why no? Because their sentence, their judgment has long become final. They had been serving sentence already. Okay, so they cannot apply for probation. The least that they could avail is that to impose upon him that modified decision by the appellate court, because that decision is applicable to him, favorable to them. Meaning to say, remember that in conspiracy, the act of one is the act of all. Hence, they must all be penalized the same, with the same penalty. So, they just have to manifest to the court that they want to invoke that favorable decision obtained by one of their accused, one of their co-accused, so that they can enjoy the modified, the term, the shorter term as obtained in the modified decision of their co-accused. So that's the list that they can avail. The trial court shall, upon receipt of the application, suspend the execution of the sentence. Notwithstanding, the accused shall lose the benefit of probation should he seek a review of the modified decision which already imposes a probationable penalty. So here, if he apply for probation, appeal, despite the fact that the trial court already imposed upon them a probationable penalty, if in case he will not be able to get a favorable judgment in the appellate court, that is actually a waiver of his right to avail of probation. Okay, so probation may be granted whether sentence imposes a term of imprisonment or fine only. The filing of the application shall be deemed a waiver of the right to appeal. An order granting or denying probation shall not be appealable. So who are disqualified from availing the provision of the probation law? If the sentence is more than 6 years, those convicted of any crime against national security, so it omitted crimes against public order under the old law. So what remains is national security. Those who have been previously convicted by final judgment of an offense by imprisonment of more than 6 months and 1 day and or fine of not more than 1,000 pesos. Now, before, in the old law, 1 month and 1 day is the disqualification. But now, under the new law, imprisonment of more than 1 month and 1 day is the disqualification. And as far as fine is concerned, more than 1,000 pesos. Those who have been once on probation, and then those who are already serving sentence at the time of the substantive provisions of this decree become applicable pursuant to Section 33 hereof. So that ends ISL and probation law. Thank you for your time.